All right. Hello, everyone, and welcome to the latest episode of Scrubbing the Skies, the webinar series of the Institute for Responsible Carbon Removal at American University. As always, I'm your host, Will Burns, the co-director of the Institute. The Institute's mission is to help formulate and operationalize a responsible deployment of carbon dioxide removal in this century and beyond. And one of the emerging issues as we start to move from the largely notional stage of carbon dioxide removal through field experiments and then through the stages of permitting research as well as potential deployment is an issue of liability, right? How do we ensure that if there are adverse impacts associated with either research or deployment of carbon dioxide removal approaches, in this case, in the context of the marine environment, we have a liability regime that's fit for purpose in terms of providing adequate compensation to those that may be injured, to deter these actions in the future, and to help generally socialize a responsible environment in this emerging field. Simultaneously, it's important for a a sector that we all acknowledge as being a critical component of climate policymaking to ensure that liability regimes do not unreasonably interfere with rapid deployment of this approach. And that's not always an easy balance in the context of any legal regime. But I think it's an important issue to discuss. And there is a new report that has been released by the Sabin Center for Climate Change Law at Columbia University that seeks to look at these very issues. And I'm pleased today to have as our guest Corey Silverman-Ratti, who is the Senior Fellow in Carbon Management and Negative Emissions at the Sabin Center and one of the co-authors of the report. As always, we will begin with an initial intervention, in this case with Corey summarizing the key findings in this report. That will be followed by a few initial questions that I will ask him to seed the conversation, and then we will move into audience Q&A. And so I encourage everyone to start populating the Q&A box when questions arise. And so with that, I will turn over the floor to Corey.
Thanks very much, Will. Pleasure to be here. I'll just go ahead and share my presentation. Great. So yes, as Will mentioned, I'm a senior fellow at the Sabin Center for Climate Change Law. If you're not familiar with our work, we are a sort of think and do tank that develops the legal tools to fight climate change, housed at Columbia Law School. For about 4 years now, we've undertaken a project to research marine carbon dioxide removal and the legal framework that would apply to these techniques, basically under the theory that the IPCC tells us that we need carbon dioxide removal in order to meet our global temperature goals for climate change. A lot of marine carbon dioxide removal techniques show high potential for removing carbon from the atmosphere, but we need in-ocean tests in order to determine their efficacy and potential impacts of these projects. And legal frameworks and rules will tell us basically how, whether, and when these projects can go forward. In all this work that we've done over the last few years to define the legal framework, we've laid out both US law and international law and some state law, and we've done some thinking around potential for legal change to help facilitate responsible research going forward, while also constricting irresponsible research. But as part of that work, we haven't done sort of this deep dive into liability considerations for carbon removal. So that's where this report comes in that we released last month. So in this report, we are talking about marine carbon removal, as mentioned, and we are talking about just sort of four techniques that have been showing like a special promise, but also some concerns around potential effects. And these are ocean alkalinity enhancement, which refers to adding alkaline materials to ocean waters to enable greater uptake of carbon dioxide from the water. This can either be in the form of adding alkaline rocks to the water or using electrochemical processes to separate into acidic and basic streams and adding that basic stream back into the water to increase the alkalinity. Similar to this electrochemical approach, direct ocean capture involves splitting ocean water into basic and acidic streams and allows for the direct extraction of carbon dioxide from that seawater, which can then be stored geologically under the ocean or on land. Ocean fertilization refers to adding iron, phosphorus, nitrogen, or silica to ocean waters to stimulate phytoplankton blooms, which then draw down carbon dioxide using photosynthesis. And then the biological pump theoretically can result into the deep sea sequestration of that carbon. And finally, seaweed cultivation, which, similar to ocean fertilization, draws down carbon dioxide using photosynthesis. And scientists have proposed sinking that seaweed in the deep sea with the goal of sequestering it for hundreds to thousands of years. So each of these techniques requires further study to determine sort of the efficacy and durability of this carbon sequestration in the ocean. They each present a number of potential co-benefits on top of their carbon sequestration potential. They vary across techniques, but these include combating ocean acidification, enhancing fisheries, and potentially alleviating environmental damages from other activities. But importantly, if we're thinking in this liability frame, they also present potential harms and risks to the environment and to other humans. And these vary based on the technique that you are using, but they include potential for nutrient robbing from other ocean regions, um, harmful algal blooms that can result from the deployment of these techniques, contamination of ocean waters with heavy metals, and potential harms to fish and fisheries. So these are just sort of an illustrative example of the potential harms that can come from these techniques. And these harms can result in potential liability under either statutory or tort law, which I will discuss further in the presentation. So if we are thinking about the legal framework that applies and the potential liability that legal framework could impose, we need to think in terms of jurisdiction and which agencies and which governments might be imposing that liability. Within U.S. waters, we have this important distinction between state and federal authority over ocean water. In general, this isn't true in all cases, but in general, between 0 and 3 nautical miles, states have primary authority and primary jurisdiction to regulate. So a bunch of state agencies and state laws will be implicated. Importantly, though, even within this 3 nautical mile zone from the coast, the federal government also retains authority to regulate, which it does so through, for instance, federal environmental law. If you go further than 3 nautical miles in most cases, and between 3 and 200 nautical miles from the coast, you are in the zone of exclusive federal authority vis-a-vis the states. So we're just talking about federal law and federal agencies being implicated here. Once you go further out from 200 nautical miles, you're in the high seas, or what some people refer to as international waters. Um, for the for some U.S. laws, they're not going to apply. There are a few cases where U.S. laws will still apply even on the high seas, and these are cases where you're using U.S. flagged ships or U.S. citizens are on board ships that are conducting marine carbon dioxide removal activities. So in our previous reports, we have outlined a considerable number of both federal and state environmental laws that are potentially applicable to marine carbon removal activities. This report in my presentation today is just going to focus in terms of statutory liability on four key federal laws. But there are a number of other potential laws that are applicable, so this is by no means a complete description of the potential statutory liability that marine carbon dioxide removal projects might face. But I think that these four statutes can provide an illustrative example of the type of fines and other types of penalties that could come from violations of US law. So, starting out here with the Marine Protection Research and Sanctuaries Act, or the MPRSA, this is a federal law that prohibits dumping in US ocean waters without a permit that the EPA provides. Dumping under the Act is defined broadly as the disposition of material. Material is defined broadly to include any types of material. And this broad definition of disposition includes disposal for potential beneficial purposes. The key distinction here is that you're putting in the water without the intention of taking it out. Another important trigger for the imposition of the MPRSA is that it must be done through vessels. So we're thinking here about, potentially dumping from ships or planes. This does not apply if you are using a pipe or some other type of structure to add materials to ocean waters. And if we're thinking about specifically in the marine carbon removal context, this is going to apply to using ships to deposit mineral-based or rock-based ocean alkalinity enhancement materials, if you're trying to sink seaweed in the deep sea, or if you're using materials for ocean fertilization. And one other caveat for when this act applies is it applies within 12 nautical miles from the coast, no matter who's doing it, or it applies anywhere if either US citizens or US flagged ships are being used. So if we're thinking about this in terms of liability, there's basically two ways that liability could come from violating the MPRSA. One is you conduct an activity that's covered by the MPRSA without even like trying to get a permit. You have no permit to conduct that activity, but you're doing it anyway. You can be in violation of the act. Another is you violate a condition of a permit that you received under the act. So if you are found to be in violation, the MPRSA includes within the law some explicit liability provisions. These allow for the imposition of both civil liabilities, in other words, fines, or criminal liability, which can include both fines and imprisonment. The violations include $75,000 in fines per violation. And importantly, each day of continuing violation under the Act can constitute a separate offense. And then one more interesting piece of the MPRSA's liability or enforcement section is that it includes a citizen suit provision. So the MPRSA's liability provisions are enforced by the EPA or the DOJ, but it includes a citizen suit provision where any individual can sue either another individual or the EPA for alleged violations of the Act, basically a way for private individuals to enforce violations of the MPRSA. Second key environmental law that we are thinking, federal environmental law that we're thinking about here is the Clean Water Act, which regulates the discharge of pollutants from point sources into US navigable waters, which includes the oceans. Pollutants are read broadly, so this can include a number of materials that we're thinking about in marine carbon dioxide removal projects, like those used for ocean fertilization or ocean alkalinity enhancement. The Clean Water Act includes the NPDES permit program, which imposes both technology limitations and water quality limitations, basically amounts of a certain pollutant that you can put into the water based on the terms of your given permit. In terms of application vis-a-vis the MPRSA, in general, the MPRSA preempts the Clean Water Act. So what that means here is that if you're using ships or vessels to deposit your materials into ocean waters, the MPRSA is going to apply. But if you're using what's known as point sources, which we're really thinking about pipes or similar structures from, say, a coastal ocean alkalinity enhancement system or a direct ocean removal system, then the Clean Water Act is going to apply, and you're going to need to get permits under the Clean Water Act. So similar to MPRSA, the way that you might end up in terms of facing liability here for violations is not getting a permit or violating the terms of your permit. Violating the terms of those technology limitations or water quality limitations might be one way. And also similar to the MPRSA, the Clean Water Act has specific liability imposition terms, both potential for civil liability and criminal liability. One distinction of note here is that the NPRSA only included criminal penalties for knowing violations. So basically that intentionality piece, but the Clean Water Act includes potential for criminal liability for negligent violations. So basically breaching your duty of care that you should have known to not breach. And similar to the NPRSA, the Clean Water Act includes a per day imposition of fines. So you could see considerable racking up of fines as a violation is ongoing over time. Also similar to the NPRSA, the Clean Water Act includes a citizen suit provision. So an individual can take a project proponent or the EPA to court for violations of that act. Also, the Clean Water Act includes a specific provision where somebody can take the EPA to court for saying that they didn't conduct a discretionary duty. So saying EPA isn't acting here where they should act, so they can file that type of lawsuit. A couple other relevant statutes that I will maybe more briefly touch on here are the Rivers and Harbors Act. The Rivers and Harbors Act requires permits for structures in ocean waters that modify or interfere with navigation. So what we're thinking about here in marine carbon dioxide removal contexts are seaweed farms that could impede navigation, or structures for the use in ocean alkalinity or direct ocean removal projects that could interfere with navigation. And in order to comply with this act, you would need to get a permit. If the Army Corps of Engineers determines that your act might interfere in this way with the navigable waterway, you would need a permit from the Army Corps of Engineers under this act. If you fail to get that permit when you are required to or violate a term of the permit, the Rivers and Harbors Act includes a specific criminal liability clause with fines of $500 to $2,500 or potential for 1 year of imprisonment. And then finally, in terms of statutes, the Outer Continental Shelf Lands Act requires leases for the use of the seabed underlying U.S. ocean waters. And this might be implicated in marine carbon dioxide removal projects that require use of the seabed if you need to be anchored to the seabed. Won't always be the case, but it could potentially be the case. And the act limits leases very narrowly to energy projects or projects that produce or support energy projects. So there's sort of this open question of whether marine carbon removal projects that are co-located with renewable energy in offshore waters can be permitted or leased under this act, or whether we need statutory change in order for that to happen. But regardless, if you use the seabed in a way that violates this act, then you are looking at the potential for liability similar to the other acts we've discussed, a per day violation that can lead to a significant racking up of fines and the potential of criminal penalties of up to 100 grand per day and 10 years of imprisonment. Okay, so that's sort of an overview of potentially applicable statutory law under federal environmental law in the US. There is also another category of law that might be applicable to impose liability, and that is tort law or judge-made liability. So these are potential liability for harmful impacts, sort of irrespective or separate from whether you are complying with federal statutory requirements. There are sort of two categories of tort law that I'm going to talk about here. One is a grouping here of federal common law and maritime law, and then another one is state common law. So federal common law and maritime law, we're thinking here about federal judge-made law. And as our report outlines, the imposition of this type of liability has been curtailed or limited by the courts, especially if you're thinking about environmental harms. And the reason the courts have done this is because they say that the Clean Water Act and the NPRSA likely preempt claims for marine pollution under these types of claims. So if someone tried to take you to federal court um, and sue you for liability under federal common law or maritime law, courts are likely to, specifically for the environmental harms of a marine carbon removal project, courts are likely to say that the CWA and the NPRSA are what governs here. Violations of those acts are the key things that are going to determine liability. Importantly, there's a carve out or a caveat within case law around private economic damage or private economic loss that came up in the context of oil pollution and oil spills. And the courts have said that these federal statutes do not preempt claims for resulting property damage or economic loss that can come from ocean activities. And this might be relevant for marine carbon removal projects in cases where we have harms to fisheries that lead to, say, a loss of income for fishermen that might lead to the bringing of a claim by those fishermen for their economic loss or economic damage to other industries or activities within the ocean. So basically, you can't sue for the environmental harms, but there's potential avenue for suits based on these economic damages. State common law, what we're thinking about here is the imposition of sort of judge-made law under state law. This varies state to state, depending on how that law has developed within each state. But there's some sort of general overarching themes within state common law. This law is likely applicable, according to the case law that we reviewed, because the Clean Water Act and the NPRSA allow states to impose stricter standards than what the acts themselves impose. So basically, this is another form of liability for activities within state waters on top of the statutory liability. Potential causes of actions that plaintiffs might bring against CDR removal project proponents include negligence and public nuisance. So negligence, we're thinking about like a breach of a duty of care that you owe the general public or that you owe an individual, and public nuisance are an interference of a right enjoyed by the general public. There is no affected state liability available under state common law. So basically, what that means is if a project has an environmental harm, like a release in, say, Massachusetts waters, that release ends up harming the environment in Connecticut, we cannot impose the law of Connecticut on that project. It's only the law of the state where the marine carbon removal activity occurs that is potentially applicable. For the same reason of this no affected state liability, there's likely no application to federal ocean waters if the harms drift into federal ocean waters, because we have this only the where the state activity occurs laws that applies, or no application of federal law there. So what this creates is potential imposition both of federal statutory law and state common law, and different rules around state common law depending on the state that you're in, and potential application of sort of overlapping and potentially confusing and potentially large sums of liability that project proponents can face given the current state of the law. Given that overlapping and confusing and potentially restrictive liability regime that project proponents might face under given existing law, in this report, we did some thinking around potential for alternative liability regimes that could both better facilitate needed scientific research, but also could ensure that scientific research that is dangerous does not move forward and that appropriate liability safeguards are in place to prevent dangerous activities from going forward. In thinking about alternative liability regimes, we thought about the forms of environmental compensation that might take place. Just a brief overview here. Different forms of compensation that could be imposed are direct liability. This is how federal environmental law works, how a lot of the statutes that I already outlined work. It's basically a polluter pays model. As you pollute, you're the one that's responsible, and you're going to have to pay liability for the harms that your project causes. Another form of environmental compensation is insurance or other financial assurance. That's basically what it sounds like. You can have governmental rules that require projects to obtain assurances that they will be able to pay for any environmental harms or human harms that their projects cause. And then a final form that this might take is public compensation funds. And this can be in the form of either the government agreeing to pay out for environmental harms that projects might cause, or imposing rules on industry that they have to pay into a compensation fund in order to have a fund available for folks that might be affected by any harms that a project causes. So one liability regime that we looked at is in the context of oil and gas pollution. This federal liability regime was created in response to the Exxon Valdez spill. And what this does is creates a system of strict joint and several liability. So anybody sort of along the chain of the oil production system might be held liable for a potential oil spill and can be held liable for the entire effects of that spill. This, in exchange for this sort of like broad-based imposition of liability, this system imposes liability caps that vary based on the perceived riskiness of an activity. So, for instance, there's less liability if you have a double-hulled safe shipment versus if you have like a less safe single-hulled system. This system also imposes required financial assurance. So these companies have to get uh, insurance or other similar assurance that they can pay for the potential harms that these projects cause. And it sets up the oil spill liability trust fund that folks have to pay into, which will then pay out in the event of an oil spill. Another liability system that was created was for nuclear power. This was created in response to difficulties in getting the nuclear power sector off the ground, around the middle of the last century. What this system does is requires each plant to get primary financial protection in the form of the maximum commercially available insurance project. If there are losses from a nuclear accident beyond that commercially available insurance, then losses are recouped across the industry as a whole. This system also imposes a cap on liability, cap on public claims that each plant might look at, and preempt state causes of action to create one unified system of liability. And there was industry buy-in to sort of this recouped from an industry as a whole because of the difficulty in getting the industry off the ground in the first place. And then the final category that I will touch on here are environmental good Samaritan laws. And essentially what these do is they limit liability for folks that provide benefits to the environment without a legal duty to do so. So there's examples of this type of limitation of liability based on environmental benefits under CERCLA and some state laws. And these impose some requirements in order to get this benefit. You have to do your environmental cleanup consistent with established best practices, and you have to ensure that the damage that results from your attempts to clean up does not result from negligence on your part. So with that, I will wrap up. The report is out on our website, and there's a link there, and then my email is there if you have any questions.
All right. Thank you so much for that, Corey. And I will encourage people once again to start populating the Q&A box, but we'll proceed to a couple of initial questions on my part. So one thing I'm curious about, and this may not just be in the context of liability, but I know you've done a lot of work in general on the regulatory framework for carbon removal in the United States. Are there instances that you've seen of significant state regulation of marine carbon dioxide removal to date?
Yeah, so we've done a few reports looking at state permitting of certain types of marine carbon removal projects. We've looked at this in the context of both seaweed cultivation and ocean alkalinity enhancement, given for the especially high level of state regulatory engagement on these topics. We looked at seaweed cultivation in California and just recently published a report on the same in Alaska and looked at potential for those states to facilitate projects going forward in a way that isn't as limited as it is in other states. But I should caveat that it is still sort of not on the radar of a lot of coastal states. There's still quite a bit of work that needs to be done to get state authorities up to speed around what they're looking at in the marine carbon removal space. One other thing maybe that I'll just touch on is there's a interest within some states now for state procurement of carbon removal.
Mhm.
And that is a potential avenue to facilitate carbon removal projects in sort of an environment of potential less federal support for those types of projects going forward.
Thanks for that. Yeah, I think that's going to be an interesting emerging challenge for a lot of states as these things start to ensue more in earnest. Another question I had is, so you talked about these potential models that we might utilize in moving forward with MCDR, and I think it was in a way again that circles back to what we were talking about at the outset, which was balancing the need for an effective liability regime with the need to try to facilitate large scale carbon removal, including in the marine context. So, in looking at those three kind of primary models, is there any one of them you would privilege, or potentially a hybrid approach, or have you not reached that point yet of thinking about where you might want to go with this?
Yeah, I think that there are elements of each liability regime that you could maybe pick out as a potential piece that you would want to include in a new liability regime that you might develop or create within the federal government or the federal legal system around a new liability regime. So you could pull, from the nuclear liability regime, this agreement across industry to have a cap on an individual's liability, and then any damages beyond that cap be across the industry as a whole, sort of an industry-wide buy-in to that type of liability regime. From the oil and pollution context, you could pull out this trust fund type thing that individual firms could pay into, that this requirement that they could pay into, that they could pay out for any harms that could come. And then I think maybe the key thing here is this environmental Good Samaritan law model. I think could be an interesting one for for projects that are going forward. Like a key concern here among folks that are trying to do these projects is I'm trying to provide an environmental benefit to the climate. Nothing within existing law like recognizes that or limits liability based on the attempt at doing an environmental good. So if you could build liability caps or rules around, whether you're actually providing that environmental benefit, and then a sort of best practices limitation on your availability to get that benefit. I think that could be a really interesting way of crafting a new liability regime. And then I guess one more piece that I'll pull out, maybe I'm just pulling out all of the pieces at this point. But that is the perceived riskiness and having that um, dovetail with the amount of liability caps that you might look at. So if you're at like a smaller scale project with low risks, you could have a much lower cap than a large scale deployment with high level risks.
Do you think, just a follow-up on that, do you think this model or these models, one of which focuses on a pretty large energy sector, nuclear, and another one that focuses on oil and gas, and then maybe even the Good Samaritan examples on fairly large-scale development projects? Do you think they would be opposite in the context of an industry that's both nascent and pretty small in terms of capital? Would it be realistic to think about risk pooling, for example, in the MCDR sector at this point, or is that something that would develop over time?
Yeah, that's a great question, and certainly is something that requires deeper thinking, and I think maybe some beyond lawyer expertise in terms of like the business case and what types of costs or fees the industry could conceivably pay into. I think the like yeah, I think there's important considerations in terms of where the industry is and when you would want to see this new liability regime implemented. And you could see, for instance, a research focused liability regime first as a way of like calibrating that system in place and then potential changes if you want to then go towards a deployment scale liability regime. But yeah, I think it's important to caveat that we're not looking at sort of an oil or nuclear sector where you're looking at potential like millions and millions in revenues immediately and what kind of liability regimes you can develop based on that.
Yeah, I think that's interesting. Okay, another question is, uh, I know that your focus in the report, it was predominantly on potential environmental human health implications of MCDR, but it seems like this question of liability is also pertinent in the context of the potential failure to deliver on purported claims, right, for sequestration. And would any of the lessons learned in terms of looking at liability regimes potentially be applicable to looking at that issue, which is kind of an issue that's bubbling to the surface recently also in this sector?
Yeah, definitely. And I think there's interesting questions around like what type of insurance instruments might be relevant here,
Mhm.
and whether you could have sort of an insurance that provides a backup carbon sequestration if a certain carbon sequestration system fails. Yeah, so I think that there's interesting thinking and like further reports that might really dive into to some tease out some of the nuances of that type of liability that could come from failing to deliver. Well, yeah, and as you stated, like what we're really thinking about here in this report is liability for environmental harms, not for sort of failing to meet the climate sequestration potential. There's another, I think, set of interesting liability questions around liability for folks that have put carbon into the atmosphere and whether a potential remedy in the form of a requirement by a court to take that carbon out of the atmosphere and what that might look like. So I think that's a whole nother interesting set of liability questions that could be teased out and could be an interesting report.
Yeah, yeah. Well, get on it, Sabin. So all right. We're going to move to audience questions then. And the first one is a hard one, especially for non-lawyers to grok. So it's from Greg Rao, and it's if an MCDR project is permitted and operating within its permitted limits, can it still be held liable for damages? Ditto for non-MCDR ocean projects, and are there examples?
Yes. So in a word, yes. That there still is the possibility of the imposition of liability beyond meeting your statutory requirements. Evidence like evidence that you are complying with your permit terms, that you are meeting the terms of a statutory requirement will certainly be presented, and that can reduce maybe um, your liability under a standard of duty of care, and maybe you're meeting your duty of care in a negligence claim. But if you are causing harms to the environment, there's still the possibility of imposition of common law liability, especially if you are acting in state waters. And Will, I don't know if you had any additions, additional thoughts on that there.
Yeah, no, I think that's right. And I think another important caveat is something that you emphasize in the report that of course when it comes to those kind of common law issues, at least when it comes to federal common law, right? There's often preemption, right? When it comes to regulations, right? And that often happens. It happens in the context of climate change litigation these days, more generally, right? So that can limit that, but usually doesn't affect the state approaches, right? So it's I think it's a little jarring sometimes for people to realize that, but it is something to keep in mind.
Yeah, yeah, and maybe I'll just expand on this preemption point a little
Yeah.
bit. So right, there's preemption across different federal laws, so that we see that in the context of the NPRSA versus the Clean Water Act, where the NPRSA preempts the application of any other licenses that would apply to the same activities. So one federal act can preempt another federal act. We have preemption in the context of statutory law versus federal common law, where a statute occupying a field can displace the availability of federal common law to come in. And then we have preemption in the context of federal law against state law, where if courts view state law and federal law conflicting, they will say that the federal law preempts the state law from applying. So there's a number of contexts where that will come forward. But yeah, as you said in our report, the federal statutory law likely does not preempt state common law claims because of their allowance for the imposition of stricter claims by the states.
Yeah. I'm curious, following up on that, is could you give an example of where the the MPRSA might preempt the Clean Water Act and the regulation of an MCDR approach, right? Given the fact that they're in theory, right, focusing on different conveyances, right? Where would there be an instance that MPRSA would clash with the Clean Water Act and preempt it when it comes to these approaches?
Yeah, so the Clean Water Act includes vessels among the instruments used to deposit materials into ocean waters. So that's a clear instance in which the two would conflict because both govern the disposition of materials into ocean waters from vessels, and the MPRSA would apply because of that preemption clause within the MPRSA.
Thanks. Yeah, I think that's an important thing and something that confuses people sometimes, right? Because there's discussions of, conveyance with pipes on vessels, right? And why why that ends up being an MPRSA regulation, even though it's a discrete conveyance device, right? So thanks for that.
Definitely. Yeah, and I think there's probably nuances within an individual technique that might get to a an interesting case before the
Yeah,
law.
yeah, I'm sure. Okay, next question from Carl Dance. What would govern ocean iron fertilization in the open ocean, for example, would the London Convention and the London Protocol apply? I know you've written a lot about this.
Yeah, so the this report just looks at liability under US law, but there is also a whole body of international law potentially applicable to these techniques, and the London Convention and London Protocol are two key instruments that are potentially applicable here. And those would um, apply to ocean fertilization and other MCDR techniques, and the rules around them would govern. There's a series of non-binding decisions under those instruments that purport to limit these types of activities just to legitimate scientific research projects. Importantly, they are non-binding, so there's a question of how they're implemented within each domestic country's government. Um, but they're sort of a signal of how the international community might view these techniques. One way that US law could apply in this open ocean, as I mentioned briefly in the presentation, is if you load your ship from US waters and you use a US flagged vessel and then you go out into the open ocean and dump these materials into the open ocean, you are implicating US law. So that's one way that domestic US law can also apply here.
Yeah, that I think is an important point for a lot of people and sometimes surprises them, right? Because they look at this neat division of, the easy and then open ocean and assume, right? And as the guidance that EPA, at least the Biden administration EPA had put out for the MPRSA, right? It emphasizes that greatly potentially increases the scope of the application of the MPRSA, right? And I think it's an important thing to remember. So, all right. Next question. You may want to tackle this one. You may not at this point. But it's a question about the impact of the Loper-Bright decision in terms of enforcing marine environmental law, right? That's probably going to require a little bit of context if you choose to take that one on too.
Yeah, maybe I'll just briefly try to touch on it. Essentially, the Chevron doctrine was a judicial doctrine whereby judges would defer to agency decisions on ambiguous statutory delegations of powers to the agencies. So basically, where judges would say, well, we're not the experts here, the agencies are the experts here, this interpretation could go either way, we will defer to the agencies. And what this Loper-Bright decision did was overrule that deference, saying that judges are the ones who should determine the ambiguity of what the statute is saying in terms of its delegation to the agencies. And I don't know that I have a great explanation of how this will impact marine carbon removal. I think there's an open question of how judges are going to move forward in terms of their analyses of delegations of powers to the agencies. It does have the potential to make permitting even more complicated in the
Yep.
way that federal agencies will need to really drill down specifically what their statutory requirements are, what the permitting requirements are in a given project, which could have the potential of delaying and drawing out the permitting process in a way that would make it more difficult to get those permits going forward.
Yeah, I think that'll be an interesting question. So, not seeing any more questions. I was wondering if you had any closing thoughts before we close out today.
Yeah, I think the maybe I'll just touch on there's one more question I saw in the chat. Just yeah, like as I said, this report looks at um US domestic potential liability for these projects. There is also a whole international legal system around liability. And that international liability comes in the forms of liability imposed on states, not on individual actors. So if you're looking at liability on individual actors, you're looking at domestic law, and in the international legal regime, you're looking at liability imposed on states sort of for failing to regulate these types of activities that could have potential harms. So I think there's an interesting further research that could look into this international liability regime, whether it's working as intended and how it might be changed to better facilitate research beyond just the US context.
Yeah, I think that'll be interesting. Also, including in light of the new International Tribunal on the Law of the Sea, right? Decision on climate change, right? How that'll interface with marine geoengineering in the longer term. So,
Yeah, yeah, absolutely. And just there's sort of a desire to look at, non-federal systems given restrictions at the federal level around climate policy making. So that might either take the form of state development for marine carbon removal, as we talked about in the
mhm.
beginning of the question session, or other countries or international law. So that's an interesting um, piece to look forward to going forward.
Great. All right. I think that is a good place to wrap it up. Once again, I would like to thank Corey for joining us and discussing this important report. Thanks to our audience for joining us and their thoughtful questions. We'll be back next month, and with that, I will say goodbye now.
Thank you.